The final NSTIC offers 4 guiding principles, 4 goals, and 10 objectives. Privacy, accountability, and technical protocols and interoperability are 3 topics that cut across these principles, goals, and objectives. Resolution of these issues requires input from practitioners and experts in multiple disciplines, including law, computer engineering, public policy, and information science. We will look at each of these 3 topics one at a time. The first topic is privacy. The use of strong identification by all actors on the internet would make the cyber realm sufficiently trusted for commercial activities and make it much more difficult for criminals and terrorists to operate with impunity. At the same time, it would far more than simply risk chilling free speech. In many countries, the government could use the identification data to literally kill dissent. This conflict was displayed when U.S. Secretary of State Clinton stated, "Online organizing has been a critical tool for advancing democracy and enabling citizens to protest suspicious election results. The freedom to connect to these technologies can help transform societies. The United States is committed to devoting the diplomatic, economic, and technological resources necessary to advance these freedoms." The State Department is already working in more than 40 countries to help individuals silenced by oppressive governments. We are making this issue a priority at the United Nations as well, and we're including internet freedom as a component in the first resolutions we introduced after returning to the United Nations Human Rights Council. We are also supporting the development of new tools that enable citizens to exercise their rights of free expression by circumventing politically motivated censorship. Yet, in the same January 21, 2010 speech, the Secretary explained, "We must also grapple with the issue of anonymous speech. Those who use the internet to recruit terrorists or distribute stolen intellectual property cannot divorce their online actions from their real-world identities." Clearly, both providing strong identification and limiting a company or government's ability to demand that an internet user provide that identification will require massive government effort, regulation, and policing in the cyber realm. Is that possible? Is it wise? If so, how best to do it? One of the 4 guiding principles of the draft NSTIC states that identity solutions will be privacy enhancing. People do use the internet for private communications or to visit websites with which they would not wish to be associated publicly. On the other hand, many times people want their online activities, such as posting an entry on a news or political blog, to be very public, but they desire to remain anonymous. Anonymity may promote free speech and political dissent, but it makes attribution of responsibility for nefarious activities very difficult. How can anonymity and security best be balanced, and by whom? The strategy states, quote, "It is vital to maintain the capacity for anonymity and pseudonymity in internet transactions in order to enhance individuals' privacy and otherwise support civil liberties," end quote. It claims that, quote, "the identity ecosystem will preserve online anonymity and pseudonymity, including anonymous browsing," end quote. The final strategy asks readers to imagine the optimal cyber identification environment. Mary is tired of remembering dozens of usernames and passwords, so she obtains a digital credential from her internet service provider that is stored on a smart card. The example continues. This allows her to run some errands digitally, including, according to the strategy, logging into her bank and obtaining digital cash, buying a sweater at a new online retailer without having to open an account, signing documents to refinance her mortgage, reading the note her doctor left in her personal health record in response to the blood sugar statistics she had uploaded the day before, sending an email to confirm dinner with a friend, and checking her day's schedule on her employer's intranet portal. In just minutes, according to the report, she is done with her errands and has plenty of time to stop at the local coffee shop on her way to work. It is interesting to note, however, that the draft of the strategy circulated for comments provided a different envision it example. It said, an individual voluntarily requests a smart identity card from her home state. The individual chooses to use the card to authenticate herself for a variety of online services, including credit card purchases, online banking, accessing electronic health care records, securely accessing her personal laptop computer, anonymously posting blog entries, and logging onto internet email services using a pseudonym. Official commentators, as well as the blogosphere, challenged whether such anonymously posted blog entries that required authentication via a smart card really would be anonymous. The draft NSTIC defined the word anonymous as, quote, not named or identified. Anonymous transactions allow for information exchange between parties without the need to identify the parties involved, end quote. That definition does not appear in the final strategy. However, it does state that the envisioned identity ecosystem will enable a variety of transactions, including anonymous with validated attributes, pseudonymous, and uniquely identified, while providing robust privacy protections that promote usability and trust. End quote. The identity provider, in the draft example a government, and in the final strategy an internet service provider, certainly does know the identity of the anonymous poster or the person logging on to internet email services using a pseudonym. The definition is only accurate if it is appended to read, quote, without the need to identify the parties involved to the parties involved, end quote. Other parties certainly will know. The identity provider and the service that authenticates that identity to permit it to post anonymously will know the actual identity of the individual. Even when the identity provider is not a government, its records will have little constitutional protection from government acquisition under the third-party records doctrine that we've already discussed. Thus, many real-world blog posters already criticized the NSTIC as an attempt to positively identify blog posters and people who use pseudonyms for email addresses. Critics rephrased the preceding paragraph as the government stating, quote, let me give you a smart card so that we will know who you are when you post anonymously, end quote. A July 2nd, 2010 New York Times headline described the strategy as, quote, taking the mystery out of web anonymity, end quote. You might be anonymous to the person with whom you are communicating, but you will not be anonymous to the government. Professor Kevin Dew of Syracuse University, on the other hand, has done research on privacy-preserving computation. He notes that this seeming contradiction, obtaining a credential to be anonymous, is not necessarily impossible, and he generally supports the NSTIC and its call for the development and use of new technology. I tried to include here a video of Professor Dew explaining how obtaining a credential can actually enhance privacy, but I could only get the video in an uncapturable streaming format. However, you can see it posted on the Institute for National Security and Counterterrorism's website or on the nstic.org blog. The final NSTIC calls for the federal government to, quote, establish and improve privacy protection mechanisms to limit the collection and transmission of information to the minimum necessary to fulfill the transaction's purpose and related legal requirements, limit the use of the individual's data that is collected and transmitted to specific purposes, limit the retention of data to the time necessary for providing and administering the services to the individual end user for which the data was collected, except as otherwise required by law, minimize data aggregation and linkages across transactions. current limitations to the retention and dissemination of wire, oral, and electronic communications, all terms with specific legal definitions, are found in the Electronic Communications Privacy Act, the Wiretap Act, the Pen Register Act, and the Stored Communications Act. Those statutes apply to at least some of the proposed identity ecosystem participants, such as Internet service providers. In highly abbreviated form, the current statutes limit providers to the public of electronic communications service or remote computing service, again, both specific legal terms, from voluntarily disclosing to the government information about their subscribers, such as physical world identities, session logs, IP addresses, and so forth, including emails. Thus, the current approach to protecting the data delineated in the 4 bullet points above is to criminalize and to provide a private right of action for collections, retentions, disseminations, and aggregations provided by acts of Congress. If the objective or action plans to protect such data are to rely upon criminal and tort law, then these statutes will need to be modified and expanded. In addition, such regulation will require enforcement mechanisms, as discussed under the second topic below. I question whether anonymity is a legitimate goal, or at least whether it should be given primacy. While surely free speech must be protected, the United States Supreme Court stated in 2010, quote, "Disclosure requirements may burden the ability to speak, but they do not prevent anyone from speaking," end quote. Aren't people more likely to commit crimes when anonymous than they would not when known to their victims? During a symposium on the draft NSTIC held at Syracuse University in September of 2010, Professor Rubin argued that whether anonymous speech can be separated from free speech really depends upon the marketplace of ideas. In the United States, we are still able to enter the marketplace of ideas, including that in the cyber realm, using our own names without fear of being rounded up by the government. People in many other countries cannot feel that way, however. Professor Bill Banks questioned how a U.S. policy might affect, for example, Iranian dissidents. At the time, I noted that if we attempt to accommodate both of the strains of the Secretary of State's speech quoted above, then we will need someone to monitor cyber traffic and to determine what is protected political expression and what is not protected terrorism recruitment. Whom do we trust to do that? How do we define what is terrorism or child pornography? Typically, noted Dean Stanton of Syracuse University, that determination is done by courts, but long after the fact, according to Professor Lisa Dolak, and my own experience, hers in the civil law and in privacy and tort actions, mine in criminal. Attribution is a term not defined or used in the draft NSTIC and used only once in the final strategy, where it states, quote, "The ability to support robust forensic capabilities will maximize recovery efforts, enable enhancements to protect against evolving threats, and permit attribution, when appropriate, to ensure that criminals can be held accountable for their activities," end quote. Usually, attribution refers to determining the person responsible for a nefarious attempt to disrupt or alter a computer network or data, as I mentioned at the beginning of this lecture. Who will make the necessary balance between trusted identification and civil liberties? Arguably, the NSTIC attempts to let individuals strike this balance for themselves. Participation in the identity ecosystem will be voluntary, it says. The government will neither mandate that individuals obtain an identity ecosystem credential, nor that companies require identity ecosystem credentials from consumers as the only means to interact with them, says the final NSTIC on page 3. This refers to two types of voluntariness. The first concerns which attribute provider a person uses. The second concerns whether a person chooses to participate at all. Individuals and organizations would be able to voluntarily choose which and how many identification providers with which to enroll, with options including both government and private providers. quote, individuals shall be free to use an identity ecosystem credential of their choice, provided the credential meets the minimum risk requirements of the relying party, or to use any non-identity ecosystem mechanism provided by the relying party. Individuals' participation in the identity ecosystem will be a day-to-day or even a transaction-to-transaction choice. End quote. The strategy also envisions a voluntary choice about whether to participate in the trusted identity ecosystem at all. A counterargument questions whether such choices really can be voluntary. An individual's freedom to choose among credentials may have practical limitations based upon interoperability and the requirements of the other party. Also, regulation will affect the available options. An individual may wish to use a weak credential with limited data, but the vendor with whom she wishes to do business may be unable or unwilling to accept that credential. Also, the vendor may attempt to require more information than actually necessary for the transaction in order to, for example, target advertising, unless regulations prohibit and enforce limitations on demanding such additional information. Freedom to choose whether to engage in online transactions at all also may be impractical. Legally, people are free not to have a telephone, but in reality it's very difficult to function in contemporary American society without one. A similar argument is made about the freedom of whether or not to get a driver's license. Moreover, the NSTIC makes a fundamental assumption that voluntariness is a desired attribute of an identity ecosystem. Is that assumption valid? Another approach would be to develop a new internet protocol that would require every packet of data to embed within it the user's authenticated identity. As a leading commentator noted, quote, it could stop most cybercrime, cyber espionage, and much of cyber war, end quote. Such a protocol is effectively a requirement to disclose a user's physical world identity. Information about the possibilities of such a protocol are the last section of this week's required reading assignment. During the symposium, Dean Elder and Dr. Shukai Chin noted that private organizations such as Yahoo and Google right now are effectively performing the function of determining the balance between anonymity and authentication in the absence of courts. Professor Bill Banks observed that historically, law has been behind. Judges seem loath to understand technology and to make policy, as we saw in the Jones and Kwan decisions from the Supreme Court that we looked at last week. Thus, asserted Professor Banks, this is one reason to be sympathetic to the efforts by the White House to develop this draft strategy. It moves these questions out into the public policy domain. Various panel discussants at the time noted that American society is evolving its expectations of privacy. It is clear that under law there is no recognized expectation of privacy for acts committed in public view. Nevertheless, citizens are increasingly drawing distinctions between what they want to be private from the government and what they want to be private from each other. Indeed, what people believe should be private, that is, not attributable or authenticatable by means of identity mechanisms deployed on the internet, are culturally specific, rendering policymaking for the World Wide Web especially difficult. My second general topic on the NSTIC is accountability. One of the stated objectives of the strategy is Objective 1.3, define participant responsibilities in the identity ecosystem and establish mechanisms to provide accountability. Interestingly, the final NSTIC has dropped language, quote, key elements of the identity ecosystem framework are defining the rights and responsibilities of the various participants in the identity ecosystem and establishing an enforcement mechanism if participants do not carry out these responsibilities, end quote. The final strategy speaks of, quote, establishing the accountability and remediation process when an identity credential is fraudulently issued or used, or when other breakdowns in the identity ecosystem occur. Indeed, the word enforcement does not appear even once in the entire NSTIC. The current language is, quote, multiple entities currently enforce online security and privacy standards in a distributed fashion across both government and the private sector. Any new laws and policies must maintain the flexibility of this approach while harmonizing a diverse and sometimes conflicting set of requirements that currently prevent interoperability and trust across communities, end quote. Some of these new laws would be the ones developed under Topic 1, privacy, that we already discussed to ensure privacy protections. Other laws, however, would need to establish the governance layer of the identity infrastructure itself. Three options for enforcement mechanisms include criminal statutes enforced in courts of law, regulations enforced through administrative proceedings, and private rights of action for damages or injunctive relief. In addition to such laws or regulations, the draft NSTIC called for the designation or creation of a governmental agency to oversee the identity ecosystem. Indeed, it was termed, quote, High Priority Action A1. Designate a federal agency to lead the public-private sector efforts associated with advancing the vision. Continuing, the White House will select an agency and hold it accountable for coordinating the process and organizations that will implement the strategy. Many other federal agencies will have implementation responsibilities associated with their respective mission areas, and some of these are outlined in this document, that is the draft NSTIC. This has been dropped from the final NSTIC, apparently in favor of the National Program Office in the Department of Commerce. Note this video clip.
We must also support strong relationships between federal agencies like the Department of Homeland Security and the Department of Commerce, including the Department of Defense. We each have a role in cybersecurity, and in this case, enabling the role of government here rightfully sits in the Department of Commerce.
Although many of the proposed tasks in this strategy might be considered persuasive in nature, implementation responsibilities would require an agency or agencies to participate in the development and enforcement of the new laws that establish the relevant rights and responsibilities. Options to be designated as the lead agency for enforcement, other than the National Program Office of the Department of Commerce, include, among others, the Office of Management and Budget, the Federal Bureau of Investigation, the National Security Agency, which is part of the Department of Defense, the Department of Homeland Security, the Department of Commerce, the Federal Communications Commission, the Federal Trade Commission, the National Institute of Standards and Technology, the White House, or an entirely new agency created for the purpose. In the last Congress, Senate Bill 733, commonly known as the Rockefeller-Snow Bill, would have assigned the Commerce Department lead agency responsibilities. Senate Bill 3480, Protecting Cyberspace as a National Asset Act of 2010, introduced by Senator Lieberman and others, and reported out of committee, getting farther than most of the cyber bills, would have designated the Department of Homeland Security as lead agency, as would two major legislative proposals in the current Congress. We will look at those also next week. Former Special Advisor to the President for Cybersecurity Richard Clark proposes creation of an entirely new Cyber Defense Administration. Former NSA and CIA Director Michael Hayden has stated that the National Security Agency will need to be the lead agency. Many people, meanwhile, doubt that the public will trust any centralized government agency, and they argue that we should continue the sort of American tradition of balkanization or separate agencies with shared powers over any enforcement area. The strategy concludes that in order to induce individuals and organizations voluntarily to participate, the identity ecosystem framework must, in general, protect individuals from unbounded liability, and in particular, ensure that individuals are not held liable for losses that they were powerless to prevent. The identity ecosystem framework should also clarify service provider accountability in order to overcome the uncertainty and fear of unbounded liability that have limited the market's growth. The strategy defines an identity ecosystem where one entity vets and establishes identities and another entity accepts them. To date, the appropriate apportionment of liability has prevented the cross-sector issuance and acceptance of identity credentials. The federal government must address this barrier through liability reform in order to establish the multi-directional trust required by transaction participants. The strategy, conceding that historically, quote, uncertainty regarding the allocation and level of liability for fraud or other failures, has been a barrier that inhibits the adoption of more trustworthy identities in cyberspace. How the federal government might reshape the liability environment to incentivize security practices without inadvertently punishing security providers for lapses beyond their control is not spelled out. Cyber insurance could be one method of apportioning liability, as could be caps or floors on liability for fraudulently used credentials. Professor Lisa Dolak confirmed that liability concerns have prevented some people and organizations from offering or using trusted identity services. The NSTIC seems to contemplate a new legal framework, but she is pessimistic that such a legal framework can accomplish the strategy's objectives. Law tends to develop in reaction to events. Certainly the traditional court system reacts after things go wrong, and that is by design. Civil liabilities compensate after someone has suffered a harm or loss. Even statutes tend to be the result of some perceived problem. Congress makes some fact findings and then issues a solution, often in result to an event featured in the news media. Professor Dolak disagrees with the NSTIC's paradigm of an ecosystem. An ecosystem, she asserts, is parts interacting with each other and evolving. Yet the strategy envisions something set up ahead of time that works beautifully, inducing cyber actors to dive in and participate. That is just not realistic, she argues. We now have a patchwork of laws with significant limitations, and the relevant civil law is less developed than the criminal law is. Claims against an institution that loses private information, such as credit card data, tend to fail in the courts. As a society, we have not yet reached an agreement about the operable standard of care. What measures should be taken to protect electronic data? What standard of care is due? What claims are reasonable? Professor Dolak explains that another problem under civil liability law is that there is no recovery where there are no damages. Until harm is proven, there is no recovery when data is stolen. A lot of data breaches are unrecoverable under the eyes of the law. Many times, she notes, there is not even evidence that such data is in the hands of someone who might want to do harm, as opposed to someone who obtained the data by accident. Even when an institution knows it has suffered harm and knows that there has been a data breach, often there is no proof that the breach caused the harm. Private enforcement of liability is just one aspect of the civil legal framework. Another is government oversight. The agency in charge of overseeing data breaches is the Federal Trade Commission. It remains debatable, according to Professor Dolak, whether the FTC has statutory authority in this area. Additionally, few, if any, FTC actions in this area have resulted in civil fines. In terms of government civil enforcement, the most effective security has come from interagency agreements. These take all kinds of forms. A classic example is that of Visa and banks capping losses to consumers. Professor Dolak sees the legal landscape developing not by virtue of government in place ahead of time, but by these kinds of private agreements that develop between parties. In the end, she argues, it will be self-interest that provides the best protection in cyberspace. During our symposium, Dean Elder reported that the business community would say that the government is already overacting. Mandated solutions are costlier than the problem, especially given that some companies already move vast value through the cyber realm. Think of international banks. Clearly, they must believe that they already have sufficient security and liability protection for what they already choose to do. Dean Stanton, at the same time, was very alarmed that placing caps on liability now may distort a system that we do not yet understand. On the other hand, will businesses participate at all in an authentication system in which there are no limits whatsoever to liability for inaccurate authentication or for loss of the confidentiality of personal data? The draft NSTIC stated, the identity ecosystem may assist law enforcement in investigating fraudulent activity that arises out of misuse of the system. But the term law enforcement is completely absent from the final NSTIC. No doubt, the widespread use of identity providers and of authentication would be enormously helpful to law enforcement. On the other hand, law enforcement can assist the identity ecosystem. Imposition of criminal sanctions for abuse or failure of the trusted identity ecosystem created by the national strategy would help to ensure its effectiveness and that it achieves the trustworthiness required for individuals to choose to use it. How best could the government use sanctions to promote trust and thereby induce people to obtain strong government-issued authentication and identification? Some examples are by requiring it, like driver's licenses backed by civil sanctions or criminal punishments, or by providing financial incentives for participation in federated identification systems, such as tax credits with criminal sanctions for their abuse, or by using choke points, that is, requiring third parties, such as internet service providers, banks, or the Internal Revenue Service, to not transact business with the citizens unless they obtain and provide the mandated cyber identification. Such regulations likely would require a massive expansion of the number of federal law enforcement agents or regulators. To date, the federal courts have struck down most state and local attempts at law enforcement or regulation of activities on the Internet as in violation of the Dormant Commerce Clause of the United States Constitution. For example, state laws against child pornography, online gambling, spam, and using a false name online have all been declared unconstitutional by federal courts. Is such federal expansion desirable? Is it financially possible at present? Indeed, is government regulation of cyber identification enforceable, given that the U.S. government owns or controls only a minor and a decreasing percentage of devices and persons in cyberspace? Constitutional protections of privacy in cyberspace, as we've noted, are minimal. So most privacy protections in a networked environment must come from statutes, not from the Constitution. Thus, some current statutes criminalize data collections, retentions, disseminations, and aggregations prohibited by acts of Congress. Nevertheless, many things that can be done with and by data are not now prohibited by Congress. In the early 1970s, when the enormous potential harm of computer misuse first became apparent, no state legislature had enacted a computer crime statute. When prosecutors first began to bring charges for computer misuse, they naturally turned to physical crimes such as trespass, burglary, and theft. The fit of physical world crimes to the virtual world proved surprisingly poor. Our courts struggled with identifying a property interest that had been taken when, after the usual data theft, the owners still possessed the property. Several state legislatures tried different approaches until finally in 1986 Congress passed the Computer Fraud and Abuse Act, which we have already looked at. That act makes it a crime to access a protected computer without authorization or exceeding authorization and thereby obtain information. Unfortunately, Congress did not define exceeding authorization, and some courts soon concluded that any violation of an Internet service provider's user agreement constituted exceeding authorization. Most user agreements are thousands of words long and contain nebulous prohibitions against uses that anyone else might find offensive. Moreover, we were told that this federal law would play a very limited role in our national system because it only applied to protected computers, defined as those in or involving interstate commerce. That may have been a meaningful limitation in 1986, before the World Wide Web, but today that definition includes every computer connected to the Internet and every cellular telephone. Similarly, there was another tension about property rights reflected in another big legislative package in 1986, the Electronic Communications Privacy Act. If you own a computer, then the data on it is yours, right? The constituent parts of the Electronic Communications Privacy Act, including the Stored Communications Act, tried to balance that common sense notion of property with modern privacy expectations. The distinction was made between public and non-public providers. Thus, Google may not publish your emails to the entire world, but your employer or non-public provider, such as a university, may. In general, the federal statutes made three distinctions between types of digital data, and these survive today. Will the data be captured prospectively or retrospectively? Is it content or non-content data? And does the owner of the hardware on which the data is stored offer service to the public or not, as we saw in last week's lecture and discussion? Based on these three attributes, the amount of legal process needed by either the government or a private entity like Google to access and share the data varies greatly, from nothing at all to so-called super warrants. If the objectives or action plans of the NSTIC to protect such data are to rely upon criminal law, then these statutes will need to be modified and expanded. In addition, criminal laws require an enforcement agency. Dean Stanton noted that it is unlikely that the United States government could create a centralized law enforcement infrastructure with personnel to do the kind of work that needs to be done. He suggested that encouraging the creation of commercial entities that would compete in a marketplace to create secure identities would be a better idea. This also would resonate with taxpayers by necessitating little additional tax money. Dean Elder noted that such a patchwork approach still would require centralized law enforcement oversight. We do not want marketers to connect the dots, but we do want counterterrorism agencies to do so when monitoring terrorists. The dots are out there, but who gets to connect them is an important determination. Professor Rubin questions what such a government agency would look like and just what its role would be. I would caution that if law enforcement is to be given any role in protection and enforcement of trusted identities in cyberspace, then investigative procedural law will need massive restructuring at the same time. Law enforcement investigations in the cyber realm have proved to be very difficult indeed. The very nature of Internet protocol communications divides them into packets of data that instantly cross jurisdictional boundaries. FBI Director Robert Mueller has described the, quote, patchwork of laws, end quote, his investigators face, as making it nearly impossible to obtain digital evidence in a manner that will maintain its admissibility in our own courts. Howard A. Schmidt, the White House cybersecurity coordinator, has noted, quote, "On the internet, there are no clues suggesting an international border has been crossed, yet sovereign rules still apply," end quote. A workshop assembled by the American Bar Association concluded, quote, "Thus, in the criminal domain, the single most significant question is one of extraterritoriality and engendering cooperation from international powers," end quote. The Center for Strategic and International Studies Commission on Cybersecurity for the 44th Presidency observed that current laws governing collection of electronic evidence may damage the nation's cybersecurity because, quote, "the sheer weight of legal complexity deters or delays investigations," end quote. Although investigative procedural law may be beyond the scope of the Department of Commerce's review and development of the National Strategy of Trusted Identities in Cyberspace, that body of law's impact on enforcing rules that protect commerce underscores the need for government-wide review of cybersecurity policy. Thus, the U.S. experience demonstrates the limitations of law enforcement as a policy tool in cyberspace. The regulation of a realm that knows no national borders cries out for a global solution, while the American public generally recognizes a social contract with, and therefore the legitimacy of, only those institutions created by its own constitution. Law enforcement may be a necessary component of a national strategy for trusted identities in cyberspace, but it is certainly only a small part of the solution. Our third topic about the NSTIC is security, interoperability, trust, and trustworthiness. This section considers some of the systems engineering necessary to support the envisioned identity ecosystem of the NSTIC. The term ecosystem is intended to connote a set of interacting components, hardware, software, protocols, certifications, and policies, whose combined behavior yields the intended properties of security, interoperability, ease of use, and trustworthiness or confidence. Professor Shukai Chin of Syracuse University explains that two important points to remember about systems are, 1, it is impossible to optimize everything simultaneously. For example, one cannot build a car that simultaneously has the most horsepower while having the greatest fuel efficiency. And 2, safety and security do not occur by themselves. They must be deliberately built in. His example is the internet was originally a network for researchers who trusted each other. Little or no network security was included in the original design, as we have already discussed. As we shall further see below, security is sometimes at odds with interoperability and ease of use. For example, if banks desire the greatest security, the only means by which customers could withdraw funds from their accounts would be to appear in person at the bank branch that enrolled them as bank customers. This degree of security is in tension with ease of use and interoperability. Example, allowing customers to use debit cards at ATMs and in stores. Details matter, so we will look in more detail at security, interoperability, trust, and trustworthiness. First, security. Professor Chen notes that security as a property typically has 3 components: confidentiality, integrity, and availability. Confidentiality is who or what is allowed to see or know of a resource. Integrity is who or what is allowed to draw from, modify, or change a resource. And availability is the quality or levels of service when accessing a resource. Security policies describe what is acceptable or not regarding confidentiality, integrity, and availability. Describing a system as secure means that its behavior conforms to confidentiality, integrity, and availability policies. It's meaningless to talk about security without knowing precisely what is meant by the term. Security policies may be mandatory or discretionary. Mandatory policies are policies that apply to everyone without exception all the time. For example, obeying traffic lights is a mandatory policy. Even first responders encountering red lights must take precautions. Discretionary policies are policies that are typically under the control of the subjects controlling resources. For example, social networking sites allow subscribers to specify who can see their information. Clarity on all aspects of security policies is essential for trust. People lose trust in institutions or service providers if they feel or think that their notion of security is violated. For example, consider the continuing furor over Facebook's privacy policies and practices on status updates, personal information, and physical location. Loss of trust occurs because expectations are violated for reasons that include misunderstood policies, inappropriate policies, failure to adhere to policies, failure to communicate changes in policies or practices, errors, fraud, attacks on the system, unintended consequences, and uncertainty. In Facebook's case, a change in their privacy practices, a new capability to track physical location, and uncertainty as to how to adequately audit who has access to that have called into question Facebook's capability to handle personal information securely. While the information contained in Facebook might be considered frivolous by some, it's not hard to see parallel perils in the handling of personal medical information, which is the continuing example used in the NSTIC. From the standpoint of confidentiality, integrity, and availability, Professor Chin suggests consideration of the following scenarios. Confidentiality. Alice's health proxy is Bob. Alice and Bob are not related. Alice has specified that in the event she is unable to make her own decisions, then Bob is to be granted the authority to terminate life-sustaining procedures if he deems the quality of Alice's life would be below Alice's minimum desires. What medical and financial information related to Alice's case is Bob able to see? Do the policies change if knowledge of Alice's information allows Bob to infer the medical conditions of her children, siblings, or parents that might be relevant to inherited diseases? Look at integrity. Suppose Bob is the only acceptable health proxy to Alice, but he is 12 time zones away and unable to be physically present. Assuming the validity and availability of the identity ecosystem as populated by NSTIC, is Bob, through his electronic identity, permitted to change Alice's medical records to include a DNR, or do not resuscitate, order? Now think about availability. Suppose Bob is involved in a serious traffic accident while traveling 12 time zones away and is being attended to by physicians in a different country. The physicians deem Bob, who is unconscious, requires emergency surgery. The surgeons require immediate access to Bob's medical records. How do they get immediate access 12 time zones away and bypass normal confidentiality restrictions in a timely fashion? Now think about interoperability. Interoperability is not specifically defined in the final strategy, but in the draft it was stated to be 1. The capability of 2 or more networks, systems, devices, applications, or components to exchange and readily use information, securely, effectively, and with little or no inconvenience to the user. And 2, the ability of independent implementations of systems, devices, applications, or components to be used interchangeably. Now, that definition is innocuous enough in appearance, but Professor Chin reports that it is both potentially complex and demanding of heroic engineering efforts by today's standards. This is not to say that today's standards of practice should not be improved. They most certainly can and should be. Rather, the above observation is intended as a clear statement that to achieve reliable and trustworthy interoperability in the identity ecosystem will be complex and expensive. To illustrate the difficulties that can arise with interoperability, defined as the ability of applications and components to readily use information effectively, we need only recall the Mars Climate Orbiter. It was destroyed as a result of NASA's interpreting data in metric units, while Lockheed Martin interpreted the same data using English units. While the loss of the Mars Climate Orbiter is a dramatic illustration of how seemingly innocuous and simple things such as numbers being interpreted as meters rather than feet can have catastrophic consequences, there are similar simple things lurking in the identity ecosystem that should cause problems. For example, take the interpretation of time. Most credentials or authorizations have an associated time or time limit. Time can be interpreted within the context of time zones, example Greenwich Mean Time or GMT-5, Eastern Daylight Standard Time, etc., or as the amount of time since a specified date in time, for example 12 hours from issue date of the credential. The reference can be to a service provider's time, a client's time, or some third party's time. In the case of large value commercial transactions, establishing whether a requested transfer falls within a valid period of authorization is critical. Establishing agreement on shared interpretations of information is important, necessary, and usually non-trivial. The second aspect of interoperability, the ability for independent implementations of the same systems, devices, applications, or components to be used interchangeably, is potentially very expensive. The reason for much of the cost is the degree of precision and accuracy necessary to specify, test, and verify the behavior of systems, devices, applications, and components for all possible inputs and sequences of inputs. Specification, testing, and verification of this kind are usually reserved for only the most safety, security, life-critical applications and systems. Professor Kevin Dew argues that as a technical matter, the identity ecosystem envisioned by the NSTIC needs to be voluntary and not mandatory. He reports that he does not know how, as a technical matter, mandatory use in cyberspace of trusted identities could be enforced. Theoretically, we could verify trusted identities for all actions in cyberspace, but the internet would be 100 times slower, according to him. In addition, mandatory use of strong identification will work only if all countries require it. Otherwise, our internet service providers would go bankrupt as online servers migrate to places where mandatory participation is not required. That, he argues, is just competition, although it does not mean that every business cannot enforce a more restrictive policy. For example, a bank might institute its own policy that for transactions over $1 million, a customer must use trusted identification. If the customer wants to maintain anonymity, he simply may choose to not perform that transaction with that bank. Thus, from a technical standpoint, Professor Dew supports the NSTIC's proposed voluntary system. Now let's think about trust and trustworthiness. Professor Chin explains that in the context of information security, when you trust someone or something on a statement, their beliefs become your beliefs, or their authority governs your actions. For example, if Alice is trusted on matters related to money transfers, and if Alice says transfer $1 million from account A to account B, then you do the transfer. Contrary to popular notions of trust, trust often is mandated, either by circumstances or by authority. People in organizations are told to whom they must listen and within whose scope of authority they reside. Trust relationships are both explicit and implicit. In some organizations, or for some transactions, trust or authority is transitive. That is, trust or authority can be passed on or delegated. In other organizations or situations, trust or authority cannot be passed on or delegated. These properties must be documented and communicated clearly. Trust is not the same as trustworthiness, that is, being worthy of trust. Just because a system is trusted does not mean that it is trustworthy. Even when a person's or a system's commands or requests may not be ignored given their authority, the correctness of their commands or requests may be questionable unless they have been verified to be correct in all cases. This type of verification requires exactly the same kind and degree of specification, testing, and verification as required by interoperability. It is not simple, easy, or cheap. To sustain trust in the information ecosystem, the trustworthiness of the ecosystem's components, networks, and devices must be established, monitored, and verified. Professor Du believes that NSTIC is lacking an assessment of the identity system's trust computing base, or TCB as it's known. You cannot build security on top of air. In terms of identities, what do we trust short of implanting identifiers the moment a person is born? Something has to be trusted. It need not be technological, and thus trusted identities in cyberspace need more than a computer science solution. Professor Du recommends considering the strategy as an engineering problem. First, we need to find people from a wide variety of disciplines to design the TCB, or Trust Computing Base. Only then can we determine how to build it. The requisite technology is available, he maintains. That is, that the NSTIC is not essentially a technological challenge, but rather a policy and legal challenge. Dr. Shukai Chin explains that ultimately the issues boil down to what will happen when there is a cyber request for some service. The provider must say yes or no. That will be determined not just by the technology or even by a properly authenticated identification. It will be determined by the policies designating who is trusted to make what statements and when. Policy is crucial to trust even after the bits all line up. Who do we trust? Who is trusted and why is very situational, and thus one solution for trusted identities will not fit all. In summary, on this third topic then, Professor Chin believes that the technology envisioned by the NSTIC is available, but that it will not achieve the goals stated on the first page of the strategy. That is, security, efficiency, ease of use, confidence, increased privacy, greater choice through interoperability, and increased innovation. To summarize, I think it's fair to say that the majority of us who participated in the Syracuse University panel on the draft NSTIC and who have examined the final strategy consider it to be vague, difficult to read, and difficult to understand. Complex as it is, the strategy addresses problems that are even more complex and difficult to resolve than the strategy presents them to be. In addition, a system of trusted identities is but one part of an even larger and more complex national cybersecurity strategy that remains in only the beginning stages of development. We generally felt that the term ecosystem is a misnomer that inaccurately reflects how various actors and influences in cyberspace actually interact. There is no silver bullet solution to the problems of authentication and attribution in cyberspace, whether for commercial purposes or otherwise. Establishing, maintaining, and verifying trustworthiness are so expensive that priorities must be set. The solution lies in much hard work, research, difficult choices, and policy making of an uncommonly interdisciplinary character. And this, with our interdisciplinary cross-section of students, is precisely what I hope that we can discuss during this week's seminar on Thursday evening.